How's it going, everybody? This is Attorney Anthony Miranda with the Firearms Policy Coalition. Today I want to bring to your attention a brief filed by FPC in support of plaintiffs in California's magazine ban case, Duncan v. Becerra. Duncan originates out of the Southern District of California and is a challenge to California's arbitrary magazine capacity limitations. You may recall that the state of California defines magazines that have the capacity to hold more than 10 rounds as so-called large capacity magazines. The state prohibits residents from buying, selling, manufacturing, importing, and possessing these magazines. In 2019, District Court Judge Roger T. Benitez found this law was a violation of the Second Amendment. However, the state of California, unhappy that their laws were deemed to be unconstitutional, saw a stay on the court's judgment and then appealed the case up to the Ninth Circuit. Ultimately, the District Court did grant the request for a stay, but found that magazines acquired during the week period between its order and issuance of the stay were lawfully possessed. The court went as far as to order the California DOJ issue a notice to all law enforcement agencies in the state to that effect. The week between the issuance of the court's initial order and the stay has become known as Freedom Week by many California residents who took to purchasing millions upon millions of magazines during that short week period. On appeal, a 3-judge panel in the Ninth Circuit also found that California's near categorical ban on LCMs does infringe on the fundamental right to self-defense and affirmed the lower court's ruling. Notably, in its opinion, the panel spent several pages of its analysis considering whether the magazines are dangerous and unusual, an issue argued only by FPC and FBF's brief. In addition to finding that large capacity magazines are commonly used for lawful purposes and thus necessarily not dangerous and unusual, the court engaged in a historical analysis finding that firearms with greater than 10 round capacities existed even before our nation's founding, and the common use of LCMs for self-defense is apparent in our shared national history. After the 3-judge panel found that California's ban on magazines was indeed unconstitutional, the state sought an en banc review by the Ninth Circuit, which is a review of a larger panel of 10 randomly selected judges plus the chief judge. FPC has filed a brief in support of plaintiffs' position before the en banc panel. In its brief, FPC highlights the history of repeating arms capable of firing more than 10 rounds, making the point that such magazines are not only common now, but have been for centuries. In fact, magazine-fed repeaters capable of firing more than 10 rounds predated the Second Amendment by over 200 years, and in fact, the founders embraced them. For example, in 1777, the Continental Congress ordered 100 rifles capable of firing up to 20 rounds from a Pennsylvania manufacturer. Also, Meriwether Lewis carried a 22-round repeater on the Lewis and Clark expedition. This clear evidence shows that California's ban on so-called large capacity magazines cannot be squared with the current status of the items in America. But also, history shows these items are protected under the Second Amendment as understood when it was written. The brief was authored by FPC's Director of Constitutional Studies, Joseph Greenlee, and was filed along with FPF and California Gun Rights Foundation. This brief, along with additional resources on this case, can be found at fpclegal.org. Also, if you're interested, FPC will be doing a limited sticker drop here very soon. For example, you can pick yourself up one of these Dianne Feinstein Respect My Authority stickers. So if you're interested, head on over to fpcgear.com and pick yourself up one of these stickers, along with other Second Amendment focused gear. Once again, this is Attorney Anthony Miranda with the Firearms Policy Coalition. I'll see you guys next time.